All right, with that, I'm going to call to order the Town Council meeting on June 2nd, 2026. This is a study session, and we have one item to discuss tonight, and that is the potential sale of the town's mineral rights. And with that, I've got a few comments logistically that'll probably be important to many people here. First, we're not going to be making any decisions tonight. If we come out of the study session and and there's no major changes or anything, it will come back to us on June 16th for discussion, public input, and a decision would be made at that particular meeting. The terms of the agreement were settled today, and so it is back in our attorney's hand, who will be looking through it tomorrow. The goal is to publish the actual agreement as soon as that's possible with an ability to put questions attached to it so that we can gather additional feedback from the community on the actual agreement. We're also working on a Q&A document for all the questions that have been asked. It'll be updated based upon the discussion here tonight. So the goal is to also get that published this week as well. For tonight's meeting, we are also going to have the opportunity for the audience to ask questions that have not already been asked. And so Debbie is here. She's got note cards or Post-its. She's going to hand them out. And what I'd like you to do is write down your questions. Even write them down now, one question per card. And then when we get to the end of the meeting, I'll ask, are you holding any questions that were not asked tonight? And if they weren't asked, then we'll collect those and we'll do our best to work on that and get those answered tonight as well. Okay, with that, I think I'd like everybody at the table here to introduce themselves tonight. Maybe the council members can just also say what district you represent. And then we'll launch into the presentation with Mr. Franks.
John Mortellaro, council member, District 1.
Matt Owens, Alameda Mineral Advisors.
John Sullivan, Sullivan Green CV Jarvis, outside counsel for the town.
Dan Hoback, council member, District 2.
Anil Pestilmelli, council member, District 1.
Emily Bear, council member, District 3.
David Frank, I'm the Director of Environmental Services for the town of Erie, and I'm also a resident of District 2.
Rita Meng, town attorney.
Meredith Muth, interim town manager.
Brian O'Connor, council member, District 3.
Brandon Bell, Mayor Pro Tem and Council Member, District 2.
All right, and if I didn't say it earlier, I'm Andrew Moore. I'm the mayor of the town. All right, with that, I'll turn it over to Mr. Franks.
All right, thank you so much, Mayor and council members. This will be, a lot of this material is the same as we discussed a couple of weeks ago in the open question and answer format, but we want to review it here again. There's also a lot of new information. Thank you, John and Brina, for making some of this available this afternoon. So, quick recap. I first heard about Draco probably would have been early to mid 2023. Obviously, there was a lot of work by the operator well before I or Weld County heard of that, but I was informed that there was an application to Weld County for a facility just outside of Erie. That began conversations with then Civitas, now SM Energy, about what that facility would look like, what engineering controls would be present, etc. Weld County heard that application in February of 2024, and then it was brought to ECMC that fall, so October, November of 2024. They ultimately made a stay while
Stay with the ECM.
Oh, sorry, the Energy and Carbon Management Commission, formerly COGCC, the Colorado Oil and Gas Conservation Commission. So the portion of the Department of Natural Resources of the state of Colorado that oversees oil and gas regulation and production. They ultimately decided on March 26, 2025 to grant an approval for the Draco facility. So that is what's referred to as a Form 2A. And that is the permit to construct and operate the surface facility, which included 26 wells, associated separators, other equipment. at that location, which is just outside of Erie's municipal boundary. After that, then the state's procedure is to then get into what happens underground. And that's through a Form 2, which is an application for permit to drill. Those have not yet been filed because prior to those being filed, you have to go through what is called pooling, which is to pool the mineral interests that was defined in the spacing unit. Obviously, oil and natural gas are liquids and they flow. So it's not like hard rock mining where you can mine this property and not that one. There's a certain area of influence to these wells. And so in the state of Colorado, other states do this differently, but in Colorado, within the spacing unit, the operator is obligated to demonstrate that at least 45% of the mineral interest is either owned by the operator or leased to them. Sometimes it's through a sublease from another oil and gas company or mineral rights holder. Once you've achieved the bar of 45%, the other up to 55% can be what's called force pooled, provided that they have been offered fair lease terms. So everyone with mineral rights has to have been given the opportunity to lease or sell their minerals. If they decide, hey, these lease terms aren't good enough, or for principled reasons, I don't want to sign this agreement, then you can be what's called force pooled, which is there is a standard agreement that the state of Colorado has defined and says these are the terms under which your mineral rights will be produced and you will be compensated. In January of 2024, legislation went into effect in the state of Colorado, which restricts force pooling of local government owned minerals within the jurisdictional boundary of that local government. This is a right unique to local governments who, of course, we own minerals that are not the town of Erie's per se, but in fact belong collectively to the residents of Erie. And since we are acting on their behalf, the Colorado legislature has decided that we are offered these additional rights whereby we can decline to be force pooled. I know that was a lot, but I think it's important background information. So in the spring of 2025, we were approached with an offer to purchase a portion of our mineral rights, namely those mineral rights that are within the Draco spacing unit that are proposed for production. We hired two consultants, one a title expert to review what Civitas was saying we owned, to say, hey, do we in fact own this, and is this the extent of what we own? And we also hired a gentleman who specializes in assessment of mineral rights valuations. That report, which was reviewed, I want to say over the summer in executive session by this council, essentially said, here's what your rights are worth, but this estimate is extremely conservative because there's not a good way to account for the additional leverage that the town enjoys due to this statute. Because the normal procedure is you're made an offer, you can make a counter offer. If both parties declined, you end up force pooled. So there's a real incentive to come to terms. The leverage is with the oil and gas producer in normal circumstances. In this circumstance, the leverage instead shifts to the local government. Because if our terms are not reached, if the negotiations are unsuccessful, then our minerals cannot be forcibly pooled and therefore must be avoided, which is a headache from an engineering and geologic perspective, to say the least. So for the past year, negotiations have been ongoing, and it's my understanding that those have essentially come to an end. Negotiations are complete, and the council can now consider whether it is in the interest of the town of Erie to sell these mineral rights, or not. That's kind of where we stand. Did I miss anything from anybody else that's been involved? So, let's talk about Draco. Draco exists, or will exist, I should say. It's been approved to be constructed near the intersection of County Road 6 and County Road 7 on the eastern side of town, so that's north of the landfill. If you've ever driven down County Road 6, it's kind of half paved and half almost unmaintained. And there is a large oil and gas regional collection hub, and it will be just north of that existing facility, near the currently being constructed neighborhood of Westerly. Draco will drill 26 wells down between 7,500 and 8,000 feet, depending on the specifics of the geology, into units called the Niobrara and Codell formations. This is, again, 1.5 miles down. And then westward, over 4 miles, not quite 5 miles, nearly to Highway 287, with production to be from this purple box that I've labeled the Draco production area. The formal name of that is the Draco spacing unit. So let's zoom out to the entire town of Erie. What we see here, there's a lot going on this map, so bear with me a second. The yellow lines are the existing underground laterals. These are the existing bores that have been advanced in this part of the DJ Basin. In teal, you see the 26 wells that are planned for Draco. This is from a document that accompanied the Oil and Gas Development Plan, considered and approved by the state of Colorado back in March. And I'm just kind of showing here that where we sit in Old Town. This was drilled under in, I believe, 2017, maybe late 2016, from the Becky Sosa pad, which is just north of us, a couple miles, just off of County Line Road. Yeah, most of Erie's neighborhoods have been drilled and fracked under, either before they were built or in many cases after. And so this is not a terribly unusual process. As you go to the other side of I-25, you can see it's pretty much everything. And you can imagine these pieces here and there that don't have yellow lines probably will eventually. This oil and gas basin is nearing maturity, where all available areas that could be drilled will have been. That's where the DJ sits. Operators are finding these last little pieces and infilling where they can. Also shown on this map, and I apologize, it's a bit hard to see because I chose blue and teal. I now regret that decision. There are a series of blue X's within that purple box. Those represent 22 existing, mostly very old oil and gas wells, who they continue to exist to hold the existing leases in these areas under the original terms until they could be replaced by these new wells from Draco. These are old vertical wells drilled in the late 20th century for the most part. These 22 wells will be plugged and abandoned within 5 years as terms of the Oil and Gas Development Plan, the permit granted by the state of Colorado back in March. There are also a series of red X's here. Those red X's are 17 wells, which are part of this negotiation, should the town decide that this is in the interest of the town. These 17 wells will also be plugged and abandoned. And I know what you're saying, hey, I've counted your X's, Mr. Frank, and these numbers don't add up. A lot of these X's represent pads which have 5, 6, 7 wells. So you're gonna see a lot fewer X's because at this scale, these wells are 10, 15 feet apart. So there are 17 X's, but they overlap each other to the degree you can't see that. These 17 wells are again old legacy facilities. These are old wells that don't have on-site leak detection, don't have remote shutoff capabilities. Most of them produce not directly into pipelines, but into large tanks on-site. Trucks have to come and empty those tanks. This is aging equipment, more prone to leaks. And those leaks are found when the operator, the state of Colorado or the town of Erie, physically goes on site and says, that's not right. And in the case of underground flow lines, a lot of those leaks may not be found until those lines are excavated, because those leaks may be below the surface. Modern facilities like Draco, every piece of equipment has a plethora of monitoring going on real time via telemetry. And if you see odd pressure drops, by you I mean the operator, if they see odd pressure drops, pressure spikes, changes in temperature, first course of action is to shut the wells in remotely and get someone on site to figure out why the equipment isn't operating as expected. None of these old facilities have any sort of capability to do that. And it's very much in our interest. We've been working really hard for years to get these old, what we call legacy wells, plugged and abandoned and off the books and out of the town. These 17, in addition to the 22 already within the permit, essentially represent all of the legacy wells owned by SM Energy. So we still have a handful from other operators that obviously we can't compel Civitas to make another company do anything, so we'll continue to work on those. But this is you know, in my mind a pretty big issue. These 17 wells are at end of life. They produce very little oil in most cases. There are a couple that could certainly chug on for a while, but there's no incentive for the operator to plug and abandon these facilities. It costs money to plug them. When they plug them, that frees the mineral rights which are currently under lease. That ends those leases, so they'll have to renegotiate those leases. Likely under more favorable terms than whatever your grandparents signed back in the 70s. So yes, they will eventually be plugged and abandoned, as will every well in the state of Colorado. But the timeline of when that would occur without this agreement is very uncertain. Certainly a longer timeline than with this agreement. And it could be, in some cases, many decades before these wells are retired. So, yes.
In what neighborhood or what area are you see the cluster up in the?
Yeah, so this is Kenosha Farms, Erie Village, that area. So this will pretty much remove all production facilities from those neighborhoods. There's also a well, it's a bit hard to see, basically where the laterals come up to the northwest and then make a jog due west. That facility is at the corner of Erie Highlands, where we're gonna be, where we're developing some commercial activities out there.
And there's the one down there in Parkdale.
And then there's the one to the south. Yeah, it's kind of near the airport. It's on the eastern side of County Line Road. But that facility in Erie Highlands, that is very much a productive facility that is right next to the residents of Erie Highlands and will be right next to the businesses opening up there. That Erie Highlands, that development predates our current oil and gas setback standards, so it's grandfathered in under the old setbacks. So I'm a bit uncomfortable with how close development is occurring to that well, and I'm glad to see that well potentially going to be plugged and abandoned.
When was that one drilled?
Well,
Oh, sorry.
no worries. I just don't know that off the top of my head.
I think what I'm gonna try to do is let David get through his presentation and then we can come back for the Q&A portion.
I believe 2011. So not the oldest well in the world. It's again still got another 5, 10, 15 years of productive life. It's certainly not low producing. Okay, so the town's mineral rights. The town has plus or minus 183 acres of mineral rights. About 80 acres of already leased mineral rights, those are shown in blue. And roughly 103 acres of unleased mineral rights shown in orange. But wait, I don't understand. The blue area is clearly larger than the orange area, so those numbers don't math. In a lot of cases, the mineral estate has been severed and split many times, and so we may only own 25% of the mineral rights. So the acreage shown here, though large, we only own a portion of that. And that's why this map doesn't pass the eye test when I tell you the numbers. So the blue area, those are already under lease terms. In many cases, those leases were signed prior to those lands being dedicated to the town. And in some cases, those leases were entered into by the town in the early 20th century. I found active leases signed by the town of Erie anywhere from about 2003 to about 2012. So those areas that in blue, those are subject to production, regardless of what the town decides today. And if the town does not sell its mineral estate, then we will receive production royalties per the terms of those leases. The orange areas are those that are subject to this relatively new act by the state of Colorado, whereby those areas could not be forcibly pooled. They could be leased, they could be sold, they could be voluntarily pooled, but they can't be forced pooled. So those are the areas that are really the focus of this. So the contents of the potential agreement. Obviously, we've discussed the additional 17 wells that will need to be plugged and abandoned. The timeline on that, I would have to refer to council.
So the Draco plugged and abandoned wells will be within 1 year of commencement of operations for the Draco APD. The non-Draco wells will be within 5 years from the date of closing. Even if we sign an agreement on June 16th, there are some steps that need to happen before we actually close, inspections and the like. So it'll be 5 years from the date that we actually, if council approves, do close. And then there's an additional well, which is the Young 431 well, and that one will be, there's two potential trigger dates. It'll be the later of January 1st, 2030, or within a year of receipt of a development notice. If we do decide to, if the council approves this deal, this particular well is located on one of the parcels and is still a producing well. And so we would then have the obligation to let them know that we are going to begin development on that particular parcel, which would then trigger the date, or the later date would be January 1 of 2030.
Thank you. The Draco facility is not within Erie, it is in unincorporated Weld County. And like all the facilities that are near but not in Erie, we don't have access to those sites. Our inspectors can't visit those sites, can't look for leaks, can't look for operational improvements. This agreement would allow us on-site inspections, I believe monthly?
Both. The answer is both. Monthly during drilling and production, and then quarterly during just production.
Right, which is the frequency at which we inspect most facilities in the town. It would not afford us any sort of actual penalty authority, if you will. That would be through Weld County in the state of Colorado. But that's fine. I have no issue with that because the state of Colorado will obviously enforce its regulations. What's important is that we can find those issues. And if anyone's been reading our inspection reports, in basically every circumstance, every single circumstance with SM Energy, every issue we found has been corrected promptly by the operator. And we haven't had any occasion to even reach out to the state of Colorado or consider any sort of punitive penalty. As far as compensation, there are 3 parcels currently owned by a subsidiary of SM Energy that would be deeded to the town. About 158 acres. They're near County Line Road. I've got a figure coming up to show you those parcels. We had those parcels appraised at about $13.5 million. I think it's also important to note that while $13.5 million is certainly a significant sum to the town, it's not a whole lot of money for an oil and gas company. And so when or if these parcels may ever become available to us or anyone else who would like to develop them is really hard to say. This may be the town's best chance in a generation to see development on the east side of County Line Road. I'm speculating a bit, but that's my read of the situation. We've also negotiated production revenue, and this is pretty substantial. Though the production is occurring in Weld County, I know it's occurring under Erie, but royalties and taxes are paid at the location that the oil exits the ground, which is in Weld County. So Weld County will benefit from taxation, from the sale of this oil and gas. Erie has negotiated a cut of this as well, to the tune of 2%. I know it's pretty complex, the actual terms. I don't really want to get into that.
Yeah.
There's a lot of funny time stuff because they need to, from their perspective, they have to make sure they recoup their losses, and the facility is actually profitable before we start taking our cut. But if you math this out, it results in something like $17 million over the course of the facility, which will be 20 plus years. These wells, when you turn them on, they flow like gangbusters, and then asymptotically you get diminishing returns over time. Same with the revenue that we'll see, so the vast majority of that will be pretty upfront. You probably get half in the first 5 years, another quarter in the next 5 years, and then less and less and less until you're getting checks that are $2.67 once a year. And then an upfront cash payment of $4.5 million. This is the location of the 3 parcels. I'm happier with my color choice here. The bright green really stands out. Parts of these lands are adjacent to existing open space and within the floodplain, so that'll probably be their fate, is to be added to Erie's open space portfolio. But a lot of them enjoy being right along that stretch of County Line Road. We've already seen some commercial development. This will help move that south. And obviously the location of the airport is critical too, given the geographic location of these properties. So that, if Julian were here, he probably has a lot more to say about these 3 parcels. I'm not a landman. That's not my forte. Here's kind of a close-up view of these. There are some existing oil and gas facilities on these parcels. Those will all be plugged and abandoned, either per the original oil and gas development plan with the state, or through this agreement should it be adopted. Okay, so that's basically the nuts and bolts of what happens if we do sell. All right, and obviously those parcels can be developed at the town's discretion, future tax revenues, et cetera, as well as businesses that the residents can patronize. If we don't sell, again, we would receive royalty payments per the terms of the leases in existence on those leased lands. And again, the unleased portions could not be force pooled. Those 100 acres can't be pooled unless voluntarily. So we could insist that since they are not part of the pool, no production can occur from those areas. Thus, they would have to be avoided. What avoided means is sort of an open question that has not been addressed because this is the first time the state's dealt with the repercussions of passing this law. I can speculate a bit. It could be that the overall direction of those laterals changes to avoid physically contacting those areas, right? You drill some this way, and then the southern ones you drill and then turn north. And you produce everything around that, but you never get underneath the town's unleased mineral rights. That's one way it could be done. It's also possible that they may drill right through our mineral rights and simply not perforate and frack those sections of the casing. I don't know if the state would entertain such a proposal. I don't know what the town's position on such a proposal might be. But those are some of the ways I could see them being avoided. At the end of the day, if the town wanted to make an accusation that no, we think our minerals were, I think our oil was in fact produced, the burden of proving that would fall to the town. We would be accusing trespass, and of course us as the claiming wrong would have the burden of proof. It's 7,500 feet down. That's going to be a tough hill a tough bar to meet. I'll say that. So the next steps sounds like we'll be back in 2 weeks. Give the public a chance to read this thing in its entirety, and we will bring a proposed ordinance for consideration by this council. Obviously, that'll be a public meeting, so there will be public comment taken, and I assume vigorous discussion by this council. If no agreement is reached, then there's not really anything else to talk about here until we see a pooling order from the state of Colorado.
Okay.
I think that's it. I think that's all I had to say. So I'll go ahead and show myself out.
No. Nice try. Now the questions begin.
Of course.
All
And
right.
I'll answer as many as I'm capable, and I'm sure everyone else at the table will have things to say too.
All right, we're in a study session format because I find it much more conducive to having a conversation. And so I'll lightly facilitate this. Any council member can ask a question and a follow-up question. I just ask that if you have a question on whatever topic it is we're talking about, let's get your questions out while we're actually on that topic. And then we'll move on to the next topic. It doesn't mean we can't come back, but just trying to group the questions. For the audience, once again, you should have a note card. Write down the questions you have. If your question has been answered, just crumple up that note card. And then whatever's left in your hand at the end, we definitely want to hear those questions so that we can hopefully shed some light on those as well. All right, with that, I think I'll just open it up to council. If anybody would like to start the questions. Okay, Mayor Pro Tem.
Just quickly, so in the event that we don't agree to this, I understand that there is some level of avoidance they have to do to access our minerals, and I realize we don't exactly know what that looks like. But is there a risk, because you're dealing with a substance that could be traveling through fissures and rock, they could extract those minerals from an adjacent property and it could deplete those minerals?
The answer to that question sort of hinges on the definition of deplete.
Well,
Would
reduce, deplete, it
could some incidental production occur from an adjacent property, either outside the spacing unit or these parcels owned by the town? It's entirely possible. Rocks do weird things. There are existing fissures. It's a non-isometric porosity and permeability issue. The rock is non-homogeneous and the oil will flow where it wants.
Okay, yeah.
On that question, I'm going to bring Matt Owens into the conversation. So just so everybody knows, Matt Owens used to be the Chief Operating Officer for Civitas 3 years ago. He has his own business which deals with mineral rights and basically acting on behalf of the mineral right owners. Matt was brought in for his unique knowledge of knowing the inside workings of Civitas. If you're negotiating, you always want to have information from those you're negotiating against. So Matt, I would love your perspective on the question that was just asked about the permeability of the rock and how that might happen.
Yeah, it's, they're drilling the Niobrara Formation and the Codell. They're microdarcy permeability, which means they barely flow any oil outside of where the cracks are. The way the state has dealt with this over the last couple of years is they kind of have you go anywhere from 200 to 460 feet from lease line boundaries. So, if you're a company and you own on both sides, then you can go closer. But typically, if a company's permitting a unit to drill and they don't own anything offset it, the state usually allows you to get between 200 and 460 feet from the edge of the adjacent lease. And that's usually based off the testimony that their engineers give, saying that's how much they think the drainage radius is. And just so you know, when they go down and complete these wells, they complete them in about 200-foot increments. So they also think that it flows about maybe 200 feet.
So kind of on that question, I gotta believe, a void is kind of a vague term, right? So they have to, in good conscience, avoid. So are there options that they can do around our minerals to technically avoid them?
Yeah, David tried to address this, and it's hard because this hasn't happened with a municipality yet. It's happened in the past with normal mineral rights owners, but there's two kind of options. They can drill again right through everything, just like the blue lines you see up there on the map. And then what they'll do is not complete that, say, 1,000 feet where Erie minerals are, but they'll do either side of it. That 1,000-foot section would be removed from the spacing unit, so there's no royalties that are paid for it, and it wouldn't be completed probably within 200 feet or ish on either side also. And that would be the production of where the well is coming from. And the other option is if they can just steer around the pieces. So it's probably isn't the best map to look at, but if you look at the one that shows the orange on there, they can turn these wells in all sorts of different shapes. Right here is the ideal way to drill it, where everything's just symmetrical in a straight line, but they can turn them in 90 degrees, they can make them look like a Tetris shape, they can make them turn 180 degrees and do U-turns. Those are kind of all over the basin now. So they have the ability to get pretty crafty with where the wells go if that's the way that they want to move forward.
So they could basically go through them in the sleeve that they put in the bore, they don't perforate.
So you have solid steel casing.
Yeah, or they could take that and drill around it and still go west, just not go through, depending on how they felt ECMC may allow them to do.
Yeah, and I'm sure they would have discussions with them beforehand, trying to figure out what they would do. It's the easiest to just go straight lines, but if they can't, there's all sorts of examples now where they do have to drill them in these weird shapes just because of there might be a floodplain or surface access in some areas is difficult, and so they have to do that. But they would have either option here, and I think they would have a discussion with the ECMC and then try to go the path that would allow them to get their permits the quickest, is what I would guess.
That would be my guess.
Okay, so let's go to the attorney and then we'll go to Councilmember Rivera.
The other factor that bears on this is the language of the statute itself, because it basically says if the municipality does not want its minerals force pooled, refuses to lease, then the commission shall deny the pooling application unless it is amended to not include in this case, the town's minerals.
Yep. Okay.
So that, to me, means you don't drill through them, you do a new drilling and spacing unit that doesn't include them.
That you go around them, basically.
Basically, yeah. engineering wise, I'm not an engineer, so I can't say how that would look, but
So, John, my question probably is for you as well. So it's my understanding the town has the right to grant a subsurface easement, or that SM Energy would have to apply for a subsurface easement underneath town-owned or property or town-owned minerals, is that right?
that is correct, yes. If the town were not going to lease the minerals, then there would need to be some sort of an easement granted by the town.
And so if what does it look like if the town doesn't grant an easement?
Then you shouldn't be drilling through the town's
Don't have to
property,
go around.
basically, yeah, cause it would be a subsurface trespass.
Subsurface trespass.
Yeah.
So what does that mean? Does that also grant the town perhaps the ability to have monitor surface impacts as well?
I'm not sure I'm following the question.
Well, I wrote it down better than I just asked it.
Okay.
So is it possible, I gotta find it though, where I wrote it down. Oh, here we go. Do we have the authority to regulate surface concerns and risks of a pass-through bore under our own oil and gas regulations? Our Title 12.
If there were surface impacts, yes. Yes.
But
It's-
it's a mile and a half.
I think at that depth, it's unlikely there'd be surface impacts, but as David was saying, rock fractures, things do come to the surface.
Yeah. Okay. So, but the subsurface easement would have to be granted in order for them to go through our, so that, it's not entirely up to SM Energy or the state. The town of Erie has some say.
For the easements, yes, because it's, to the extent it's town property that's being used, the town has to consent to it the same way it would consent to any use of town property.
So if I really understand this conversation, first, the law says you can't go through it. Second, if we don't agree to this. Second, if for some reason we said, okay, we don't want the minerals, you can go through it, then we need to have this subsurface lease. There's no reason that I can see that that would happen. They would go around us. Or am I missing something in this conversation?
If they wanna go through your property, they need permission to do it.
Totally
And they
get
get that through a lease, through an easement,
Right.
a license, something like that.
Right. I just, from what you said before, with the way this law is written, I can't imagine that that would be the play. Because both paths, right, I either go through it and don't frack, would require us to do a subsurface lease, so that's not gonna happen. Or, they would have to go around us, which means all these things we're talking about don't apply because they don't affect us.
In your hypothetical, they wouldn't be going through the town's property or under the town's property.
John, can I
Correct.
ask this question? See all this area right here?
Yeah.
That gets drilled through, but isn't leased? There's no easements granted out there.
Right.
So how can they
The state
do
certainly
that?
allows the borers to advance through all of these mineral holders' properties with no lease or easement.
This is a legal theory,
Sure.
okay? And so, the legal theory also says what you own on the surface goes to the center of the earth.
Yeah.
And of course, because the earth is round, that surface gets narrower the deeper you go.
Now I'm confused, like what is the final answer for this? Can they go around, and if they go around, how far is it? Like you said, some miles? Or when you showed that it is, they're already doing it without permissions
I've spoken with
or easement?
I've spoken with engineers at the state and they don't have a firm answer to this question. Their response is the applicant can propose what they think is best and the commission can either grant that or deny it. And the staff at the state is not willing to speculate on what the commissioners will do with these questions.
But I think the path of least resistance from their standpoint would be just to
Go
drill
around.
around it.
That avoids all these nasty questions, for sure. It also costs more.
Okay, I'm gonna come back to John, because I think you had other questions.
Not on that
Okay,
particular one, but, so I can ask it later.
let me make sure that we've addressed the drilling through, the drilling around, the drilling under, the legal piece around that. Okay, go ahead. John, if you have another question.
So it came up, a conflict of interest, hiring Matt, as, our consultant on this. Is there any conflict of interest, from the town standpoint?
The town defines conflict of interest from the perspective of the town council members, town board and commission members, and town employees. It does not put a conflict provision on any other entity than those entities.
And so Matt, is there any conflict between you and SM Energies, to you being our consultant?
Not that I'm aware of.
So, and they've been negotiating with you with no concerns?
Mm-hmm.
Do you own stock in SM Energy?
No,
You don't own stock in SM Energy?
nope,
Neither directly nor indirectly?
Do you own Civitas stock?
there's no more Civitas stock, but I don't own SM Energy now.
All right, other questions?
Well, I don't know, I do have questions about that. I think that that's been a major concern in our community, and I don't know how we get to a place of feeling like all of those concerns have been addressed, but
I think what everybody needs to know about the agreement with Alameda Minerals is that Alameda Minerals makes $0 unless we strike a deal. So it's based, the incentives for Matt and his company are to do the best for us because it's a percentage of whatever we get. So if we get a lot, Matt and his team get a lot. If we get little, Matt and his team get little. So just by the agreement, it's incentivized to be acting in good faith with us.
No, it doesn't actually, because when they get paid, they're getting paid based on the information that they're using from that company, right?
Well, yeah, this is how
And
negotiations
whatever
work.
it is, they're getting paid because of it. So you want me to finish or you want to interrupt?
Yeah, no, keep going.
So it's not the same thing, right?
No,
You're
I
not getting
disagree.
paid if the sale doesn't move.
No, I
So
disagree.
all the interest is for him to get this through.
Yeah. When you're doing any negotiations, you could hire whoever you want. I mean, I've been doing negotiations for decades and I always want the smartest team on my side. And the smartest team is often people that know the other side really, really well. And so that's just basic negotiations.
That's not smart actually. They're using confidential information from there.
It's not confidential. Well, let me ask Matt, are you negotiating confidential information?
From Civitas's
Yeah.
or SM Energy's perspective?
Yes.
No.
So all this information is public information that he is using in the deal?
It is information that Alameda Minerals has.
The
So this-
DSU was submitted to the ECMC how long ago?
2024 approved March of 2025.
And all that's public information.
Oh, yes.
Yeah.
Oh, yes.
Okay, other questions? Yeah.
So, kind of easy one, the real estate valuation, do we have appraisals on that?
Completed last year and this year, like December to a month ago. They're very recent. Thank you, Julian.
So you said we have 103 royalty acres that are proposed to be a part of this deal?
Yeah, the full, I guess, I don't have a copy of the deal in front of me. I think it's a plus or minus 183 total acres of mineral estate, 103 of which are currently unleased, and roughly 80 of which are subject to existing lease.
And what, I'm not sure this is, well, happy to estimate, do you know what percent of the total Draco area that might represent?
Oh man, I wrote that down. The unleased area is like 5%. It's 3,700 acres, and we're looking at 100 acres of that.
Yeah, the drilling and spacing unit that was approved last March, or March of '25 was 3,951 acres. There's a current amendment application to reduce that acreage to around 3680, 3690. Yeah.
The unleased portion would be 2.7%.
Now, to avoid that area, you're gonna have a larger area that's gonna have to be excluded. And let me just do some real quick drafting. You're looking at maybe 300 acres, so 10%, a little less than 10%, 8% of the full spacing unit would probably have to be avoided to avoid our 2.7%. So 90% of the spacing area could move forward into production, and we'd prevent production on about 8 to 10%.
How much of that would require going around our properties in a haphazard zigzag kind of a way?
I'm not gonna speculate how they're gonna propose avoiding our property. I don't know. I don't know to what degree that would increase potentially the length of laterals. One of Erie's primary concerns are that these laterals are very long, the longest attempted in the state of Colorado. Is it in our interest to make them longer?
Alright, so to put this in sort of context, our royalties are projected to be 17 million-ish over time. At 2%, that's $850 million of gross revenue. If we're 2.7%, okay, this is about a $31.5 billion transaction or project for SM Energy.
Sure. I mean, that's probably more, yeah, gross proceeds, right, Matt? I don't know.
I mean, their gross revenues on this pad will probably be somewhere in the neighborhood of 1.5 billion.
What number did you say, Councilmember Hoback?
31.5 billion, sorry.
So you're saying 31.5, you're saying 1.5 billion. So we've got a math discrepancy there somehow.
Yeah, we have a severe math discrepancy because we're saying 17 million to the town of Erie at 2%. That implies
That's 800.
850 million.
Okay.
Sure.
And that's only 2.7% of the whole project. So the whole project, backwards math, 31.5 billion.
You did that twice.
Yeah.
Yeah, you just do it once. 17 million divided by 0.02, but.
Yeah, we're getting,
The point
we're
two is
getting
our
2%,
portion.
we're getting 2% of the total proceeds of all the production.
Oh, not just our share?
That's right. Everything that comes out of the tap, we're getting 2% of that
Which we think will be 17 million.
projected. Could be a little more, a little less.
All right.
Heavily dependent on the current price of crude, which has been volatile.
Okay.
And that 17 million, that was calculated before the Iran conflict, right?
Yeah, that was back in like January.
So-
timeframe.
That's assuming things go back to a regular, stable market that we enjoyed in 2025.
$60-ish a barrel, I'm guessing. Is that what was stable before they ran?
What we used was we were like 65 and then it gradually stepped up to about 74 over like a 5-year period. But not the 105 or 10 that we've been seeing recently.
So where do we stand with the title work?
We We are all in agreement except for one area where title opinions are opinions. And our opinion and their opinion does differ, but there is a portion of this agreement to address that. Whereby we agree not to claim to own that piece, right?
That is correct. There is a provision for what we're calling the disputed minerals. There's two places in which we don't know if we own or if we have already leased out those mineral rights. And so there's a process in which we would disclaim and waive any right we would have, assuming we had any interest left. There would also be a provision for if after closing, we discover additional areas within the pad, we would be compensated, assuming we sign the agreement for those additional minerals that we find.
Right, so, but at some point here, in the next couple of weeks, we'll get a full map with parcel numbers and everything that's being sold?
That's this map. I can give you all the parcels if you like.
Okay.
We believe it is complete, but the title work might show something different. We don't believe that is the case, but it's theoretically possible.
Are any of those highlighted areas parks or open space?
Not with a capital O and a capital S.
Doesn't have to be.
I mean,
How is it
are
zoned?
some of these areas undeveloped? Absolutely.
Okay. What are they currently designated as?
What do you mean designated? Has
So-
this council designated them? No. Have they been
Zoned.
zoned?
Hey,
They have
hang on,
not. Sorry.
hang on just a second. I need to get onto my laptop.
Absolutely.
In well, I said that and now I'm gonna speak extemporaneously, which is not a good idea. In 2024, the then council passed ordinance number 017-2, 2024. An ordinance of the town council of the town of Erie amending Title 10 of the Erie Municipal Code to create a new reserved open space zone district. In the finding of fact, the town noted that the current agricultural and open space district does not meet the intent of the town's home rule charter regarding open space designation and desires to create a new zoning district to do so. Excuse me. And so the then council designated abbreviation RO for reserved open space. That would be the charter compliant open space designation. It is my understanding that we have no RO designated in the town.
What about open space ag?
There is no AGOS zone parcels.
So there's no other OS whatsoever.
Not in this area. None of these parcels are zoned as ag open space.
Yeah.
Most of them are under PD overlays. So they're all mostly zoned either medium residential or PD.
Okay. What competitive bids and comparative analysis did we?
I'd probably refer to Matt on that one.
I've,
We received a formal lease offer from Civitas, which we declined, because it was a pretty standard lease offer and wasn't reflective of the town's leverage position because of the legislation. We received, I think, 2 other formal lease offers from other oil and gas companies for parts of the estate, not the entirety, but again, those were pretty standard 18% lease offers.
And when was that?
Over the past year, so 5-6 months ago.
Okay.
And again, we declined those because they were an order of magnitude or 2 below what we're currently talking about.
Okay. But you didn't do any competitive bidding?
before I was hired by you guys, I worked for another client in this unit that had a bunch of minerals at the end of last year. I solicited a bunch of bids for leases and for him to monetize those. I followed up early this year with those folks to see if their bids were still in the same range before we had, I don't remember which one of the meetings, but the one where we went over the longer presentation. And I talked about where those ranges were showing up in there, and like David said, it was substantially lower than what this deal would be. And so at that point in time, it was determined to just focus on this deal since the value discrepancy was so large.
Okay, that does not sound like a competitive bid process to me.
So just following up on this a second, and if memory serves, before we had contracted with Alameda, we'd received another offer from Civitas at that time. I believe, if memory serves, the land value was only, I think, the 2 parcels on Arapahoe, and one of them was like contingent, like they weren't giving us the land, it was, we had to meet certain criteria or something, and the monetary value was way below what we were even able to determine just off.
Yeah, the initial offer was for just the southernmost of the 3 parcels, which appraised at that time for 2.8, give or take, $2.8 million. And the lease terms, the back of the napkin math would have resulted in total payment of about maybe 4.5 million over the life of the wells.
If I remember, and correct me if I'm wrong, we actually approached Civitas because we wanted to buy a piece of property. And at that point, they said, no, but we'd be interested in, we were not willing to sell you that property, but if we might negotiate if you were open to selling your mineral rights.
Yes.
And then we talked about, then they came back with the other piece of property that was just north of there. And both were lower than what we would ever have considered going into a deal with. So we kind of kiboshed that. At that point, it was after that Matt was hired.
Okay,
I have a
well,
question.
that's my recollection.
Okay. So is there a possibility of Civitas sending these lowball offers and put this later on?
And what?
Is there a possibility of Civitas coming with all these lowball offers and then come up with this current situation of the mineral deal?
Yeah, I think over the course of the last year, the town said, hey, we're gonna need the absolute best offer you can put out there. And this is where we landed. As far as compensation, we said, we don't just want this one parcel or these 2, we want all of your land in this area. We said we want a cut of the production royalties, we want an upfront cash payment, we want access to the site, and we want you to plug every one of your old wells in town.
And just to be clear, we had that information that this might be possible because of Alameda Minerals. We didn't have that perspective.
Right, before we hired Matt, we were talking about the 2 parcels, which in total were 70, 80 acres. And that's about all that was on the table in December.
Okay. It's one thing to have, prior discussions and going back to them and get it, that still is not a competitive bidding process. And your scope of work says you will complete a competitive bidding process.
It does, that's why in that executive session we had, I specifically asked
I
everyone.
would ask that we not talk about things that happen in executive session.
I mean, that's the only way to, determine if we are getting fair value for the product, the sale. I think that's it for now.
So following up on that, I have some language from the contract. The scope of services and consultants' duties The consultant shall conduct a competitive bidding process to secure optimal lease proposals, including valuations of monetary and non-monetary terms for town-owned mineral rights and property in the Draco Plan area. And the consultant shall solicit bids for the sale of town-owned mineral rights and property within the Draco Plan area with comparative analysis of upfront proceeds versus projected cash flows. So the competitive bid process was required in the contract that was approved for Alameda Minerals. So then council, I guess we could ask you to, I'd like to see other offers beyond from SM Energy.
So I want to make a point of order here because we have two sort of competing things here because we cannot talk about what was talked about in executive session. However, I feel this line of questioning is completely disingenuous because you all know what you heard in those things.
Absolutely not.
All right, hold on. So tonight, we're here to talk about the agreement.
Yes,
I have never heard another offer from any other entity.
that's not true.
So that's good that we can't talk about executive session things because that is not something we've ever talked about.
So whether we did or didn't, obviously, we're not gonna talk about executive session. What we're here to talk about tonight are questions about the agreement that is in front of us. And so I'm gonna bring it back to that and to see if there are any other questions with that. I'll start with one that came in, and that was, where's the water gonna come? Because the process is water intensive, is my understanding. And maybe you can talk about what water intensive means and where the water will come from.
Is that part of the agreement?
That is not part of the agreement. The water will not come from the town of Erie. I can say that. Where they choose to buy water from, it is gonna be a lot of water. Matt, do you know off the top of your head what they're, I don't remember what's in the OGDP, but it is a lot of water.
Be probably somewhere in the neighborhood of 500 million gallons.
And is that water lost in the process or is it reclaimed? What happens to that water?
Nearly all of it will be lost. Will need to be subject to deep injection for permanent sequestration. A little bit will be reused again as frac fluid for other wells.
Yeah.
But no, none of it's ever coming back to potable.
So this goes back to, I think all of us would not like to see that water used. But regardless of whether we accept the lease or not accept the lease, we've been told Draco will go forward. It's just in what, what is the drilling plan for it? So it's frustrating, I get that, but we, as far as I know, I'm looking to our attorney, we don't have a legal way to use that as a way to stop the Draco.
We have control over our jurisdictional boundaries.
We would limit it. We would reduce it a small percent, but.
Small percent, yeah. Okay, and let me bring in some of the other council members. Councilman O'Connor, any questions?
Regarding the proposal, is there any mention of coyote trails in there?
There is no.
So that's been all removed.
There is no mention of coyote trails.
And regarding the 158 acres, in the appraisal, did it have an indication of how much of that land is actually developable?
Well, I knew there was gonna be a jillion questions. Let me do a little reading and I'll come back to that.
Okay, sounds good.
Okay, while you're doing that, I'm gonna go back to a question where David and John were going back and forth around whether rock formations could impact surface. And I think, John, you said, yes, they could impact surface, and I think, David, you said it's 1.5 miles down, it won't impact surface. Do we have any cases, actually go back one slide, I think it is, to the where we're already fracked under? So Vista Ridge, for example, or Collier's Hill have been fracked under. Have we had any instances where there's been surface changes due to the fracking that has happened in those cases?
Not to my knowledge here. This basin, the DJ Basin, let's go back to the time of the dinosaurs. There was an ocean here. The Cretaceous Interior Seaway had deposited about 5,000 feet of shale. That shale is very impermeable. And somewhat prone, if there are fractures, to sort of self-heal, if you will. That's not to say that hydraulic fracturing hasn't caused effects at the surface in other areas. There's a lot of reported and, in my opinion, scientifically valid accusations of what's called induced seismictivity, especially in places like Oklahoma, where the injection of these high pressure fluids has activated existing faults, basically lubricated them and allowed slip where previously the strains hadn't been overcome, thus resulting in small to medium-sized earthquakes. We have not seen that here in the DJ Basin, to my knowledge. I have, if there's a scientific paper out there, somebody send it to me, because that's of course of great interest. There are also other places where oil and gas production, whether through hydraulic fracturing or otherwise, has resulted in communication between these oil-bearing strata at depth and potable aquifers near the surface. This often occurs either through existing fractures or through the annular space of the wellbore. So they drill a bigger hole than the casing they put in the hole. Obviously, you can't put a bigger pipe in a smaller hole. Anyway, the state of Colorado has about the strictest regulations in the country as far as how that casing is in place, what cementing is required, how much cement, quality of cement, depths, and then what sort of geophysical logs have to be run to verify that the bonding of that cement between that steel casing and the rock. Other states are less judicious in that protective, in those protective procedures, and there are certainly cases where it is at least it's been accused, and perhaps validly, that potable aquifers have been contaminated. I've not seen that in the state of Colorado. I haven't seen valid studies on that phenomenon. But yes, that's always a possibility. Just to say that it hasn't occurred, or it hasn't occurred to a significant degree in the state of Colorado or near Erie, doesn't mean it couldn't.
Got it. But there's no evidence that it has occurred in Erie at this point?
Not in my lit review. Again, if people have papers, please send them to me.
Right. Okay.
Because I love reading stuff.
Mayor, I can answer a little bit of your question. Julian left me some information. It's not in acres. It's in square foot, long-term.
Could you re-ask the question, just for context for those who might be listening in later?
So the question was, how much of the 158 acres is developable?
So Julian says the long-term build-out potential was estimated at approximately 700,000 to 1.1 million square feet of non-residential development, generally for aviation-related businesses, including hangars, aerospace suppliers, aircraft services. Those types of things is, the hope would be a greater airport.
But that's on that lower two. Well, I'll probably have to follow up with Julian, because
Yeah.
it doesn't,
Yeah.
it seems like the
That's on the lower
larger-
two, but that's what he says, on the full 153 acres is what would be.
And Julian regrets not being here this evening. I believe he will be back in 2
Yes,
weeks.
he's actually on vacation.
That's good for him.
Yes, we do let him have vacation occasionally.
How did that happen?
And then immediately regret it. This will be the last vacation for Julian.
I think I can shed some light on a previous thing. I'm asking it this way. So obviously our choice here, so it's our minerals. We could either choose to sell or lease them to Civitas, or another option would be to go out to a public market and to essentially sell it or lease it to a third party, who would then probably lease it back to Civitas. So, but for having that kind of deal, the land was owned by, what was it, 7N or, so, yeah, which is SM Civitas. So for the land portion of that, we could not lease with a third party and, well, I guess with the land in consideration, that was a constraint.
Yeah,
Is that fair to say?
obviously the parcels would be off the table. The 17 expedited plug-in and abandonments would be off the table. Inspection access would be off the table. You'd be talking about some combination of upfront cash in the form of a lease bonus and then some production royalty on just that acreage over the term.
Okay, so it's fair to say that money was not the only consideration here.
Yeah, no, there's a lot here that SM Energy can uniquely provide. And they obviously have the most incentive to acquire this land.
Yeah.
But what is the need of leasing them?
What's the need to lease them? The town doesn't need to lease its minerals. We certainly could say, hey, we want to make a principled stand. We're not under the illusion that Draco's going to go away. There will be a large number of wells, probably 26 wells drilled. And you know, and fine, we'll take what production royalties we get from our existing leases, but no, there's no reason we need to.
Yeah, is there a possibility this is worth more tomorrow?
No, this will never see value this high ever again. We are moments, especially geologically speaking, from imminent production. There's a permit to produce these minerals. This is absolutely peak value. Anybody in that purple box that would like to receive monetary benefit from their subsurface estate, today's the day.
And is there a chance that if it is delayed, Draco has to deliver something within time frame, right?
Yes, they are constrained. They must be in production no later than May of 2028. And the ECMC, the commissioners, gave direction that they should do everything within their ability to be in production by October of 2027, which is not long, 15, 16 months from now.
So what happens if they don't do it by October 20?
Your guess is as good as mine. That will be a matter between the state of Colorado, this operator, and the adjacent landowner, Southern Land. I'm sure the town will have a role to play should it come to that, but I think everyone involved would probably like to avoid that.
But it's highly unlikely that Draco, which is a $1.5 billion operation, is gonna go away, or any attempt that we try to delay it isn't going to really affect what they're going after.
If I were sitting on the other side of the table, if I was an oil and gas operator with $1.5 billion at stake, I would try to fulfill the requirements of my permit. And I would try really, really hard to do that.
Their attorney has told me that they will go forward without the town's minerals.
Yes. That would be my guess.
Okay, I'm gonna pause for a minute here, and I think if there's any questions that are in the audience that we haven't asked yet, if is Debbie still here? If Debbie, maybe you can collect those, and if maybe Meredith, if I can ask you to just look at them, read them, and we'll go from there.
So in the meantime, I have a question that sits in the SM Energy 10K from last month. They submitted that to the SEC that with respect to our operations in the DJ Basin in Colorado, in some cases, we do not own more than 45% working interest or mineral interest in a prospective area of development, which is now required because of Senate Bill 181 to to pursue statutory pooling or achieve voluntary pooling agreement with 100% of the applicable interest owners. So I'm curious if we have more leverage than we think. And since we don't have a competitive bid, I worry that we're leaving potentially not money on the table. I mean, money on the table, but I mean, while it was sort of made known to them that we were interested in the parcels of land, they sort of shifted focus to dangling that carrot in front of the town rather than giving us.
Yeah, I guess the way I look at this is the first offer was 2.85 million, this is that land. And now we're up to roughly 35 million plus the value of the land going forward, which goes to over 200 million. And so, yeah, maybe this isn't the best deal we can get, but maybe it is by far the best deal we can get.
Where are you getting the $200 million?
There was a
Economic
question
development.
that staff had answered earlier. The question was, is there an estimate future economic value of the 158 acres? It estimates that a build out to the highest and best use of a 30-year tax projection is anywhere from 46.2 to 209 million. And I think what that basically is saying is that that land, which we don't control today, has locked up value. And so the appraised value is basically for open land, right? That it doesn't have any benefits to it yet. But once you unlock that, and then the economic value potential can be achieved, then the numbers go way higher than that. I think the other thing from the land perspective, by the way, the land is the biggest piece of this from my lens, because there's economic, but there's also town benefits, especially right around the Leon A. Rural Service Center, where we're looking for space to expand that for Parks and Rec, and we don't control the land, Civitas does, or SM Energy does. And if we don't go forward with this, I think we should all get prepared that the economic development and the ability to get that land from SM Energy may not materialize, because, you know, we basically, you know, have had an adversarial relationship with them for years, and, you know, now that we have an opportunity to turn that around, if we say no, they're gonna hold that land, or at least that's what I would do if I was in their shoes. That's the hard business reality of it.
Just for punitive reasons, they would hold the land?
In the fact that the oil and gas doesn't really need the land, they're not in the land business, so my guess is it's not a big deal to them to just hold it.
Yeah, they invest in these properties to negotiate. When leverage is needed, that's the purpose of these land holdings. That and to potentially site oil and gas facilities on, that was probably their original intent. But after SB 181, these parcels aren't a viable location. There was at one point, I believe it was called the Vessels Pad,
Okay.
to be located here. Thankfully, that didn't come to fruition.
On one of those parcels that is in this package.
The northern one. And so, yeah, if a deal's not struck today, it could be that the economics become right and they wanna sell it to a developer. I can't say that won't happen.
In fact, has in recent history, because the Acme pad was supposed to be on Bonanza and Highway 7, and they sold it back to a developer
They did.
to be developed.
It could also be that they hold these lands until the next time they need something from the town.
Yeah, so I mean, we even approached them to buy, I mean, that's how this whole thing started, we approached them to buy the piece of land and they told us no, initially. But they said they would enter into a discussion if we were willing to talk about. And, you know, we talk a lot about the compensation part of it, but, you know, to me, the 17 plugged and abandoned wells is a huge benefit. I live 500 feet from an active well that they're currently plugging. And it's been a very frustrating process, but I'm gonna be extremely excited when that well is plugged and abandoned. And I gotta believe the people who lived around these 17 wells are gonna be excited to know that there's a timeline that these things are gonna address. I mean, to me, that's on top, the compensation. There's some strong health and safety improvements that we're getting out of this.
O'Connor, Councilmember O'Connor, to go back to your question, for the appraisals, you're looking at about 5.4 to 5.5 acres are within the floodplain and can't be developed.
Okay.
That represents about 3.5% of the parcels.
Okay.
Is any of it restricted because of the airspace in development?
I do not dabble in FAA regulations at all. I'm sure there are some weird height
Yeah.
restrictions
I mean,
and
yeah,
some
the-
weird light restrictions.
Definitely the flight path.
Don't build
Through
anything
one of
that
them.
looks kind of like a runway. How about that?
Yeah.
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 All right, I'm gonna look to our acting town manager and see if we have other questions that have not been addressed tonight.
There are a few questions that I believe relate to items from the executive session that I'm not gonna
Okay.
ask. Does the absence of an RFP when hiring Alameda constitute a breach of town charter? And does the lack of soliciting competitive bids construe a breach of contract?
Okay, that's probably a question for you or
So-
attorney.
There is no requirement in either the town charter or the town code for RFP or solicitation. There is a requirement that was adopted in a purchasing policy approved by council to conduct RFPs or solicitations for services like this. That did not happen.
And just as an aside, I will say that in the last couple of months since we found that this was done not in accordance with our purchasing policies, that the town is putting in procedures with the finance department, so something like this wouldn't happen again.
So it is a violation?
Of our purchasing policy,
And we don't have a sole source type,
there is a process, a sole source process in the purchasing policy that was not followed.
okay, neither one is followed.
Will any type of environmental impact studies be conducted prior to the deal agreement being signed?
I can answer that. There is a 50-day period after assuming a deal is signed for the town to conduct what's called a phase 2 environmental. That would be an invasive testing process where we would be able to select a vendor to go on site and conduct some analysis. The reason we put 50 days in there is because we have heard from vendors that it takes approximately 5 to 6 weeks to conduct a phase 2. 6 weeks would then give us a little bit, 2 weeks buffer time for us to have any unforeseen delays or additional testing. So yes, there is a phase 2 built into that, in which if the town doesn't like what it receives, it can walk away.
Would the 17 wells to be plugged, is there a possibility that they would be plugged outside of this deal?
Eventually, all the wells in the world will be plugged. But when is the question? I have no idea. In the case of a couple of them, no, they wouldn't be plugged for decades. Maybe the case for all of these. The wells that are up near Kenosha Farms and Erie Village, those are on the Boulder County side of the line. You can look at this map and see how difficult it is to get wells located such that they can cross the county line. And those wells aren't gonna go away until another very large Draco-like facility is approved somewhere in the area. Of that I can assure you. Maybe one or two of them, but not all of them.
Has SM ever said Draco would not go forward if Erie declines to sell or lease their rights?
No, in fact, they've told me quite the opposite.
Is the Thomas Reservoir zoned as park or open space?
Not zoned, no.
What's it zoned as?
I believe it's part of the PD.
Basically, I think the question is, if the town sells their mineral rights, would that bump Civitas's or SM over the 45% needed to force pull everybody else?
No, they've got more than 45% with or without us. And I'll also say, a subtlety of this agreement, as I understand it, is we're actually only selling the rights to the Niobrara and Codell formations. In other parts of the DJ Basin, there are other geologic units that are productive. Not so much here, but technology may change that. There's also a lot of strata below those units before you hit the basement. And maybe a future oil discovery would be made there. In those cases, if we see a project proposed in this area for, say, a unit above or below these two very specific formations, we still maintain the mineral rights in those other units. And so we could prevent pooling or renegotiate those rights separately at some future date should geologic knowledge, engineering, or a combination thereof revisit this location.
And just to add to that, there's a new exploratory well 2 miles to the southeast of Draco that's in a new deeper formation that's producing right now.
There you go.
How, approximately how thick are those two formations?
300.
Yeah, it's not, in the whole package, very
Yeah,
thin.
yeah, that's what I-
If they were sitting here, pretty thick. Yeah, a couple 100 feet.
And the size of that drill is about 9 inches? That's gonna go through that, 300 feet?
Yeah, usually production casing's 5.5. I don't know how tight they try to drill these
5.5
days.
inch- 5.5 inch casing, and then they'll drill like a 8 inch hole.
Yeah.
6.5 inch hole.
When they begin advancing the bore at the surface, in order to facilitate the surface casing, like I said, all the cement that has to be driven all the way through all of the viable aquifers, that hole's more than a foot in diameter. Those are scary. Those are big enough to fall in. But then it tapers down stepwise. By the time they get down there, it'll be 8 inches or so.
Is an earthquake a surface impact? I think isn't that a possibility?
Sure, yeah, I would definitely consider that if there is demonstrated induced seismicity, earthquakes occurring as a result of this or any other fracking. Depending on the magnitude, you could have anywhere from minor shaking and you need a new glass for your family picture, up to structural damage. That would definitely be surface effects.
I think I heard you say earlier that Oklahoma has this problem, but
Very
did you
much so.
say Colorado doesn't have this problem?
It is not well documented in Colorado. There's always gonna be some questions. Scientific, there's so few earthquakes in Colorado anyway. This is a very seismically inactive area, especially for a mountain range.
And so there's already seismic activity in Oklahoma? I don't understand the geography.
Yes,
but-
so, and you can sort of look at the frequency and magnitude of earthquakes prior to that field being developed and after. I think it's pretty obvious that fracking has caused some substantially increased seismicity in that area.
In Oklahoma, but we haven't seen it here in Colorado. I'm just trying to make sure that I understand.
Yeah. And there's been a lot, of course, a lot of scientists very interested in that subject.
Sure.
I'm always open to reading more literature.
There was seismic activity attributed to the Rocky Mountain Watershed when they were pumping stuff down into the ground decades ago.
Yeah, typically you'll get induced seismicity when you do injection adjacent to the basement rock, the crystalline granites. That's quite a ways away from where these wells are fracking, and much more an issue when you look at deep disposal well development, because as Matt said, this porosity in these units is terrible. When you're doing deep injection, you need nice sandstone that you can push lots of fluid into. In this part of the world, the only sandstones that are deep enough, nasty enough, and porous enough are the Lyons sandstone and the Fountain. And in some places you can find the Entrada Formation, and that can be a target. The Fountain is often off limits because the Fountain Formation is the flat irons. It sits right on the granite. And EPA says if you start injecting into the fountain, you may in fact be injecting into existing faults in the granite, and that's what tends to cause earthquakes.
Okay,
But then we have class 6 injection wells nearby in Erie or outside Erie.
There is a deep injection well just outside of Erie, near Highway 52 and I-25 at the Hammer facility. Again, what they can inject into the fountain is very, very little, and it's resulted in that well not being a terribly good deep injection well.
all right, next
I
question.
grew up in Oklahoma and did not experience earthquakes growing up, and then we moved to Colorado in 2000. And sometime after that, soon after, they started having earthquakes. So none of the homes were built with like earthquake technology or, to try to mitigate those effects. But all my family still lives there, and my sister lives in a house that's 106 years old or something, and it's a major concern for
Yeah, for
Oklahoma.
that
She
area.
lives like right in Oklahoma City, so.
One thing I'd like to point out on that topic, most of the earthquakes or seismicity that happens in Oklahoma and Texas and New Mexico, southeast New Mexico, it's not from the drilling and completing of the wells, it's the injection of the produced water. So to put in perspective, in the Permian Basin in Texas, they inject somewhere between 25 and 30 million barrels a day, which multiply that by 42, and you're, billions of gallons of water every single day into those disposal wells. And here we inject next to nothing compared to that. I don't even think we inject a couple 100,000 barrels of water. This basin doesn't produce water. So we talked earlier, when you pump the water in the ground, it doesn't really come back. A little bit comes back, but only about 15%. In Texas, if you pump 1 million barrels in the ground, you're gonna get 10 million barrels back.
I was gonna say like
So you
10,
get like 10 barrels back for every barrel you put in the ground. And so it's all those injection wells. There's probably like 3 or 4 million just injection wells down there, and in this basin there's probably 30. It's completely
It's a
completely
different-
different. Yeah.
And permitting a deep injection well in this part of Colorado, it's really difficult. EPA Region 8 is notoriously difficult to get a permit from.
All right, I'm gonna bring us back to the questions for this agreement.
Right. We're talking science, it's exciting.
Does it require a supermajority of the council to approve the sale of real property?
No, it requires an ordinance.
What's the best case scenario of not taking a deal or selling the minerals with the timeline? Do we have any chance of minimizing environmental impact or stopping the project?
I think we've addressed that one.
Yeah, I don't think we're gonna stop the project. I think you're gonna lose the ability to inspect the site. These 17 wells are gonna hang around for a long time.
But it does shift the dominant mineral estate doctrine in favor of those folks who don't wanna have their homes fracked under, and that they don't have implied right, so they wouldn't be able to drill through those neighborhoods that are in orange on the other map.
Yeah, that goes both ways. Homeowners that own their mineral rights in those neighborhoods, yeah, they may be drilled under, may not, certainly wouldn't be fracked under. They also would not receive any compensation for their minerals.
But we would have to grant an easement for them to be drilled under, correct?
That's a legal theory.
But they can go around and
But
there
if they
may
go
be a
around it,
ditch
it's gonna
going on.
affect people that would have been affected by it going straight. You're gonna affect different people by going around, and you're actually gonna make the tunnel longer, the drill longer.
Yeah.
I think we know that it takes, we have 5 years to plug the wells. How long does that usually take, and what incentive do they have to plug the wells, and what if they don't plug the wells? So how long would it be for them to plug the wells if we weren't required, they weren't
Well-
required to under this agreement?
I mean, to plug a well is 2 to 5 days. But there's a question of rig availability. They have to hire a company, subcontractor to come out and do this work. There's also then potential remediation from any leaks that occurred at the site and went unnoticed, unreported. That process can be quite lengthy, years. We've got one active remediation project that's just crossed the 2-year mark. Very frustrating. And then you have reclamation to follow that. You gotta grade the land and establish seed. That's another 2-year process. From my understanding, they have to initiate the plugging within. I don't know, I haven't read the final draft.
The well itself will be gone in a couple of days. It's the surface.
As they get to them, and we'll work with them on the order in which they occur, so we don't just have an army of rigs, land on Kenosha farms, because that would be a terrible nuisance to have an army of rigs up there.
These are commencement dates.
Right.
So they have to begin this work within those timeframes.
Does the agreement contain monitoring and potential mitigation near a number of previously capped wells, such as the one at Amber Court in the Meadow Street Farm neighborhood?
So there are 6 wells. I'm not sure if that exact one is one of them, but that was negotiated with the operator during the OGDP hearing, pre-hearing conferences. So they will be monitoring of those 6 wells, which the town identified of highest concern. Regardless, that is part of their permit with the state. The other plugged and abandoned wells in the town, Town of Erie is launching a pilot program this summer to start looking at wells, collecting soil vapor samples and assessing if there's a potential for leaking. Depending on how that pilot program this summer goes, we will be launching a full-scale program, and we're gonna do our best to look at every single well which we can gain access to. Obviously, wells on private land will need consent from the landowner to look at the well, and if somebody doesn't want us to collect samples on their behalf, we won't.
For the minerals that are already leased out, the blue area, what are the terms of those leases? Who holds those leases? Will they be up for renewal during this? Can they be refused as part of Draco?
That's a very complex question. There are dozens of individual leases signed over decades in a variety of terms. Some had heavy cash upfront payments that went to whoever signed that in 1974. Some have higher royalty payments, some approaching 20%. Those were made with a myriad of different companies, most of which don't exist anymore, and they've been traded about on the private market. I have no idea who holds those leases today. I'm gonna guess most of them have found their way to SM Energy's hands. No, they won't be renegotiated. The terms of those leases are that they are active until after production has ended.
What laws are in place for the proximity of wells near a school, and how far is Draco from an Erie High School?
It is, oh geez, John, how far is it? Is it 2,000 feet strictly, with no exceptions?
Yes, pretty much. There is a rule, an ECMC rule that allows you to get closer if you can demonstrate adequate mitigation measures.
And we've seen that to individual residences, but
Yeah.
not to schools. That doesn't say that the state couldn't
Yeah.
approve a facility, they just haven't yet.
I wanna
and
make sure I
it's-
understand the question. Erie High School isn't that close to the Draco pad, or?
To the school itself is a little over a mile, to the edge of the school property is right at a mile.
Yeah, but they have to be 2,000 feet away, is that what you said?
Yeah.
Yeah, so we're over double that.
Yeah.
Yeah.
But there's a school site within the Draco setback.
Yes.
That doesn't exist yet.
A proposed school site, we did, of course, that was one of the very first phone calls I made, was to St. Vrain Valley School District when I heard about Draco the very first time back in 2023 to make them aware that this land that they were talking about potentially siting a school at was going to be about 1,800 feet from an oil and gas pad. There is no there is no state law or, as far as I know, within the school district, a hard and fast rule about where schools can be cited vis-a-vis oil and gas locations. The town setbacks don't apply to school districts because they're an extra governmental authority. So it would really be up to St. Vrain how close they want to build schools to oil and gas pads. And if you've ever been up to Frederick High School, sometimes it's really close.
Different era.
And the hub was already there when we platted the school there. It was just when Draco came in.
Yeah, and the distance from Draco to the hub is, I don't know, 700 feet.
Yeah.
Okay, I'm gonna
There's
keep
that
the-
other pad that's there already too.
Yeah, there's also the windsock pad, which is, it's actually an oxy pad, which has always baffled me, but.
All right,
Nuance to the
next
business.
question.
What regulations are in place to protect health of the community and its safety, and are any of these guaranteed in the contract?
There are no additional guarantees outside of what already exists in both state law and our town code.
And Weld County code.
Yes, thank you.
But there's air quality monitors that are required, the state requires air quality monitors around Draco. Plus, we're also going to have our own air quality monitor between Draco and the closest residents at Westerly, right?
Correct, but none of that is germane to this deal. That's all gonna happen anyway.
Right.
Yeah.
What do we do with that information?
The air quality data that we collect, obviously, we can always give the state of Colorado a call, whether that's ECMC staff or the Air Pollution Control Division. We do regularly share things that we find. I meet with APCD, the Air Pollution Control Division. We meet with them quarterly. Us, Broomfield, and now recently Frederick has joined those conversations since they have an oil and gas liaison. To talk about what monitoring is happening, what have we seen, what concerns we have. Obviously, if we have something not routine, we don't wait till our quarterly meeting. We get Ashley on the phone straight away. Same with ECMC staff. Enforcement of air quality standards is not something the town is equipped or probably even allowed to do. That is the purview of the state. So that's what we would do with that information. Of course, we also send out notifications to residents about the data we collect as soon as it's collected.
You also have it online, right?
Yeah, there's an online.
You can actually go to a
You can go to the
website
online data.
and-
Everybody
and
should
see
be
it.
cruising around the Boulder Air site. It's cool. You can look at all the air quality data we've collected.
All right, is that the end
I
of?
think the other questions either relate to executive session conversation or they're not pertinent to the exact contract.
Okay, sounds good. So I'll come back to here. Any other questions about the contract and this topic? Go ahead.
Yeah, I'll just ask one more question, just because it's been asked of me by a number of residents, and that is, do any council members own mineral rights within the Draco drilling areas?
No, I own property, but no mineral rights.
I'm getting like a $15 check every once in a while.
And that's
Years
from
have already
Draco.
been leased or, yeah.
Yeah.
That's the yellow lines.
Yeah, must be one of those yellow lines that's already drilled.
Let me see, yeah.
Yeah, that question has come up and whether I even own oil and gas stock, and I do not.
So John, can you talk to us about why we would sell versus lease minerals? I've been told that generally leasing is the smarter thing to do is from a money standpoint.
There's no, I guess it depends on how you wanna collect your money. There's no law that prevents a mineral owner from selling his or her minerals. Leasing has been the norm in the DJ Basin for as long as I've been dealing with legal issues, but, you know, and there are many landowners who purchase land and the minerals have not been severed. And then they own the surface and they go ahead and lease the minerals underneath. And there may be various reasons why a landowner would do that. But I know that it's really an individual choice. And I'm not sure. My understanding is the leasing option in this instance, and as David noted, the leasing option just simply did not return the value that the sale option did.
Okay, would we have more, like, if we owned versus selling, if we leased versus selling, would we have more, authority as a local government over impacts? If there were surface impacts?
You would have the right, if you own the surface, you'd have the right to say whether the surface can be used. But in Colorado, the law is that the mineral interest takes priority over the surface interest. It's the surface owner must make reasonable accommodation to the mineral owner, assuming that the only way to access those minerals is to go straight down from the surface. And that issue's been, I guess, minimized by the advent of horizontal drilling and fracking, because you can access minerals miles from the well pad site.
So I guess what I'm asking though is if we were to lease the minerals rather than sell the minerals, do we retain any authority by leasing versus selling?
You would retain the authority under the written lease, which is, you know, it's generally the right to receive the royalties, and I presume the town would negotiate a lease in such a way that it wouldn't allow the surface to be used to access the minerals, because that's generally the biggest issue for a landowner.
There's also looking ahead 40, 50 years, say the Draco wells are plugged, abandoned, new technology is introduced that says, hey, now we can drill even farther and frack even harder, and someone wants to come and re-stimulate this part of the formation, then we would, if we had leased and that lease had expired, which is a very rare circumstance, then we could renegotiate, whereas with a sale, yeah, these will leave the town's hands forever.
Except for retaining
Yes.
everything but the 300-foot zone.
Right, in these two formations.
Yes. Yes, as long as the lease is produced, all the leases I've read, as long as that lease is producing something, 1 barrel, that lease is in effect. And that doesn't always make a landowner very happy because they're not getting much in the way of revenue. But Boulder County found that out through litigation, that some lands they wanted to be freed from a lease, but the judge found that they were continuing to produce a very minimal amount, but the lease was in effect. So the lease can hold for a long, long time.
I think that well was drilled like in the 30s.
I don't recall, but I just, yeah. I'm gonna bring us back
Yeah,
to
sure,
the
sure,
area
yeah.
of Draco pad. So the next step, will be 2 weeks from tonight, where council will, decide whether we approve the agreement as discussed tonight or not. That agreement will be posted on our website later this week. There'll be a way to ask questions or put comments in, so that input can also be, put into the public record. We will, also have a Q&A document that is being worked on right now, that will also be published sometime later this week. And then we'll be back at this. I believe right now on the 16th, this is the only item on the agenda, but I don't want to promise that will be the only item because it's another meeting where there could be other things added. But right now, that is the focus of that.
Brina, can you draft a memo about the purchase policy violation and kind of let us know what that entailed, what that means and what happened there? I just don't understand it, so I would like to understand more.
Yeah, and Sarah's already working on that in
Okay,
finance.
I think also when our auditors
Yeah, our auditors
come in
have
this
noted
year,
it.
we should add this to the audit list.
They have noted it as a finding or a possible finding, so that's part of why we are, another reason why we wanna make sure we make remediations so that the process is fixed.
And then the other thing was that I do have concerns that the contract, the scope of work for the contract wasn't met with a competitive bid or so I would like to understand more about that. Was that a violation of our expected scope of work of the contract that we signed? Those are questions that I'm getting in the public as well, so.
All right. And just all the procedural things, we definitely need to address those. What we'll be addressing on the 16th is the contract we have in place and whether the terms in there are in the best interest of Erie or not. All right. Well, we did this in under 2 hours. I appreciate all the conversation and the depth that we went. David, I appreciate all your background and expertise to help guide us, and for our attorneys and for Alameda Minerals, who has the background. Appreciate all of that. With that, I'll adjourn the meeting.